Welcome to Bonus Bytes, a special mini episode of the Triple D podcast. These bite-sized episodes are packed with information about disability benefits, disability news, and answers to your burning questions. Get ready to take a bite of what's going on this week. Here's your host, Michael Weiner.
Welcome to Bonus Bytes, the next episode of the hottest podcast on Apple. I don't know if you knew this, Andrew November, Michael Weiner here. I don't know that we were just rated the top up-and-coming podcast in all of Apple Podcasts.
I mean, I'm not surprised.
Now, I am the selection committee.
Oh, okay.
So I'm the one who made this decision, but I'm very excited.
So basically, in your heart, we're number one.
In my heart, we are definitely...
Download subscribers, not so much. I mean, for all 8 of you, thank you for being here.
Yes, that's right. No, I'm telling you, I don't know why people listen to this, but people are listening to this. People come up to me.
I told you someone came up to me at Scott Perlmutter's open house and said it. Someone I'd never met just walked up to me and said they knew me from the video.
It happens all the time now.
Crazy.
Yeah.
Well, we provide good content.
I think you're very entertaining. Who's our sponsor this weekend?
Yes,
Look at this.
This is Dr. Kevin Burrows. He doesn't know he's sponsoring, but I'm tired of paying his chiropractic fees, so
there we go.
Hopefully that ends today. Dr. Kevin Burrows is a chiropractor in Lakewood that he does a lot of functional medicine, and I think that's important. You know, as us fighting for our clients, we need to stay healthy too. And this is someone I see. Now,
I've noticed today you're wearing the lime green CPC t-shirt, but in past days I've noticed the same t-shirt in other colors.
You've noticed blue and gray?
Blue and gray.
Yes, and there's more out there. There's black. There's a hoodie that might come up in the winter episodes.
So these are all swag things that you currently possess. He's given you all of this?
Yes. Well, no, I actually purchased these.
Oh, you've purchased these?
Yeah, I'm actually dumping a lot of money into this practice. So, now he's a sponsor.
Wait,
that's going to change.
That's incredible. So
I bought it because I think it looks good, to be honest.
You are paying money to advertise for Dr. Kevin.
Yes, and paying him for his services.
He must be good at what he does.
I mean, honestly, I bought it because I liked how the shirt fit, so I just bought all the colors.
You look spectacular.
I'm in pretty good shape right now. I'm feeling good.
Are you?
Yeah, I was outside a lot. I was on vacation, as you know. I did a lot of running in the mountains of Washington State, so feeling healthy. Did a run this morning.
You ran in the mountains?
Yes, it was perfect. Everyone, in Cleveland knows we're not known for our great air, especially where I live in Tremont. It's borderline disgusting. So when I have the privilege to go to Washington, where my wife's family lives, I ran every single day I was there. It's
that's great.
Such fresh air. And you know what's really interesting about it? I had an interesting observation. I use this Fitbit. I've had it for years. My average heart rate was 20 beats per minute lower the entire vacation.
Why do you think that was? Were you less stressed?
I think that's probably a part of it, but I wonder if the air too. I mean, because most of my running's before work, and I really try to block out, I always, when I wake up, I say, this is your first task. And don't think about it again.
Right.
So I'm going to come in, write this brief, and I'm not going to think about it again until I sit at my desk. But that's probably weighing on you to some extent.
Yeah.
But when I'm on vacation, it's vacation. But 20 beats per minute is a significant difference.
Definitely. So why don't we start talking about what's new in the news? We've got some interesting headlines to discuss. One thing that just came out, we talked in previous episodes about how this current commissioner that we have, Martin O'Malley, there's been so many exciting changes that more than you and I can ever recall in a short period of time since Commissioner O'Malley started not even a year ago. But the newest one that just came out yesterday is now at the Social Security hearing offices. They are actually going to be more involved with the record retrieval process. And where we identify for the hearing office the existence of records from a provider who participates in what you know as the HITMER program, Health IT Medical Evidence of Record program, which is basically like an online record retrieval portal that Social Security has access to. They will get those records. What do you think that's going to mean for our cases and clients, Andrew?
I mean, great. I have so many questions about HITMER. Any of the attorneys that practice in this area know what we're talking about, but basically Social Security has access to medical records with authorization, of course. Clients sign authorization as part of the application packet, and they can get records instantly. And they're amazing records because they have a beautiful layout, a very formulaic layout where the progress notes are in one section, objective imaging's in another section.
Yeah.
What I've always found confusing is I feel like judges were not, like, they're hesitant to do these requests. I'm like, what are they paying for this? I never understood. Like, the judge would be like, hey, counsel, can you try to get it? And then if you can't, I'll do it.
I mean, you know what it is. It's laziness.
Is that what it is?
Of course it is.
I was like,
of
what?
Course
I didn't know if they were getting like nickel and dime on it.
No, the Social Security is not paying anything for this. I think it's part of the government's push to try and make sure that all medical records move to electronic. Using this system is not only cheaper for Social Security, it's also cheaper for the medical provider.
Right. I mean, how do we get that? I mean, we could do a whole episode about these companies, these evil companies that handle medical records.
Oh my God.
I understand with these giant institutions, they need a separate department just for medical records. But with the advances in electronic storage, and we're seeing evidence in the Social Security office, why don't we have that?
I have no idea.
I mean, we have a whole team of people that just screws around with these providers, with these companies, and luckily we're in a state where we're entitled to one copy of records for free with an application for Social Security.
I don't know if you saw, there's a couple more states that are going to be rolling that out soon, and as our practice is expanded really across the country, I think this is going to be helpful. Michigan is now going to have a law that looks like Ohio's and Illinois.
It's crazy. I mean, we do represent people around the country. It's a significant cost. I mean, some of these records, are hundreds of dollars because say you have a hospital stay, minimum 200 pages of records for even like a day. Like, there's just so much notes that go into it.
And the problem is that most of it's garbage.
Yeah.
Most of the medical records are just repeated instances of things over and over again. I'm sorry, I don't care whether my client had the chicken or the beef for lunch when they're in the hospital. I just want to know what the discharge. Right. I want to know what what treatment they were given. I want to know how long they were there for, and I want to know what the next steps are for them after they're released. But we end up paying hundreds of dollars to find out every single time that somebody walked into the room to see if they were awake or asleep.
Exactly.
And that's good. Maybe that's good information for the hospital to have, but it's useless for us.
No. Yeah, it has no use for us. It just creates more pages, which means more money because they charge per page, and it's an expensive cost. Do you ever read the discharge instructions?
Yeah, I think that's where a lot of the gold is in the medical records.
Yeah, there is some stuff in there, but you can find the prescriptions a lot of times, especially for assistive devices.
Yeah, right, but also things like that's a lot of times where they're told, okay, on discharge you should be continuing to elevate your legs and doing different things that can be the force behind a favorable decision.
Yeah, and that's a lucky situation. Isn't it amazing how many times a doctor will tell a patient something that never makes it to the record?
All the time.
Especially elevating legs. That's like the number one thing, because it's like offhand, when you get home, just keep your legs up as much as possible.
Right.
And that, is an incredibly significant limitation for any work.
Basically rules out all work.
Yeah.
And here's what's interesting. We spend so much time trying to get documentation about canes, walkers, things like that. We'll still run across vocational experts who will testify that somebody can work, with a cane for balance, with the use of a walker in the workplace. And we push against those. We cross-examine, but it's pretty uncontroverted that when somebody needs to elevate their legs to waist height for a significant portion of the day, which is common for so many impairments, they can't work.
Yeah. I actually had a VE in some, flyover state testify that someone could be an escort driver and still elevate their legs. And I'm like, how is this possible? Like, I want to be a judge. Like, it was a judge that was clearly a low payer, like, had no interest, probably knew this was the answer I was going to get. I'm like, really? Like, and this is a product of bad representation, because these VEs, think about it. We come in for one hearing a day. That judge is at 6. So 5 out of 6 hearings, the V's getting away with this crap.
So what happened? What happened in that circumstance where the V said?
Oh, I mean, with cross-examination, they have to give up. I mean, like I had to explain how a vehicle works and how legs work, and then when we put it together, you cannot elevate your legs and drive a car. Maybe if you're like a cyber truck that drives itself, but there's no way you can do it.
Oh my gosh! No, in a cyber truck, you still need to put your foot on.
So there's no vehicle out there.
There's no
vehicle. Until we have drones moving us around.
Yeah. I want to come full circle to this though and talk, back about the records. I'll tell you why I'm excited. In most of the content that we put out, you and I believe would agree that the two most helpful factors to a successful disability case are, one, getting a treating source statement, having your doctors offer an opinion about what they think our client's limitations are, and the second thing is having a complete medical record at the time of the hearing. It makes cases move more efficient, and when you've got a complete set of medical records, nothing's missed. That's where the fringes get paid. That's where people who, maybe the judge is missing a batch of medical records that would have made a difference in a case. So with Social Security now stepping in and participating in the in the record retrieval process, I really think that our clients are going to be benefiting from it.
Yeah, and we'll benefit too, which means our clients benefit. Yeah. Like, one thing that we've always agreed on is we love reading the most recent medical records first, because medical records always have a HPI, history of the present illness. So I like to know what's going on the day before the hearing.
Yes.
And then I go back to the onset date because, we need to prove that the person was disabled from the date that they said it began. But when you go to court and you don't have the last 4 months of records, it really puts you in a tough position, puts the court. And, I think that judges really make up their mind in the hearing. Like, I know some cases there's probably more deliberation after, but I think a lot of decisions are probably made on the spot.
Definitely.
And if, we kind of lose the court's attention, we want them to focus, make a complete file. I love saying, is the record complete? Absolutely. Like, I celebrate that fact. I'm proud of how many times our records are complete, even with the challenges we face.
Well, and we bonus our staff based on that.
Yeah.
I mean, specifically, if you look at the incentives that we have for our staff, that help them do better, that's one of the 5 things that we are incentivizing them to move cases efficiently, and we are looking for them to have medical source statements, and we are looking for them to have complete medical records, because we know judges like it.
Yeah, absolutely. And I know that my chart is an option from time to time.
But it's not as good. You're right.
It annoys the judges, and that is a problem for the clients because it's hard to find the gold. With HITMER, it's obvious. It's a chronological summary. With my chart, it's sectioned. You've got your lab results, your imaging, and it's just too hard. And we got to remember, judges are human beings. They're not wanting. I think one of the judges, I won't say his name, in Cleveland, I'll tell you off the record, said he doesn't even want those anymore.
Really?
Yeah.
Interesting.
It's I'm not going to say anymore, but someone did call and tell us they don't even want it, which I'm not sure. I don't know. I don't want to get into that fight right now, but that was not surprising.
I think we should update our viewers on, in the last episode that we have, we talked about the possibility of there being a government shutdown.
Crisis averted.
Crisis was averted.
For 2 months.
Doesn't it seem like they never actually resolve anything? They just temporarily resolve things?
I mean, I started paying attention to politics probably my 2nd and 3rd year of law school. That was when, Bush was kind of on the outs towards the end and Obama was getting elected. And it's been like this every year. It's just kicking the can. I mean, how many continuing resolutions have we had? It's always just keep the lights on.
Now, I understand around election time, the odds of them passing a long-term spending bill are probably nothing, just because, each party's jockeying for control right now, and they're worried about making a deal that they regret later. But, once we get into a new administration, I really hope that we can have some sort of continuity, some sort of finality that'll keep the government open and functioning for a long period of time, regardless of who's in charge.
Yeah, that's why we need President Kirkman from Designated Survivor. Don't spoil it for me, but I just watched the first season, and he rallies the nation together, and he's got his first 100 days, and it makes me kind of sad. Like, that will never happen. Like, we can't all just agree that this is better for everyone.
Only in Hollywood, Andy.
Only in Hollywood, so
yeah.
Sorry, no President Kirkman.
I want to leave some time to take some questions from our viewers. I'm going to ask Richard to read them to us because I didn't.
I've been wanting to get Richard into the podcast.
Yeah, we got to work him in now.
I want him slightly off mic.
We're gonna keep him off screen intentionally here.
Okay.
Let's see.
He'll make his debut soon. I can see him.
I have a question right now. What is RFC? I'm currently applying for benefits and I'm not sure the best way to fill this type of form out.
RFC is a legal term. It stands for residual functional capacity. Bottom line of what that means is what can you still do despite your condition. So we've talked about the sequential evaluation process. We have a ton of videos on that. But at the end of the day, Social Security is going to kind of come up with a set of restrictions for you. Maybe, for instance, they'll say you can lift no more than 20 pounds and, because of your difficulty with focus, you can only do simple routine work. So they come up with that 20-pound simple routine work, and then they ask two questions. Can you do your past work, and can you do any other work? So the RFC is really just that. It's what you can still do despite your conditions. The form part of that question, I'm not really sure. Maybe
they're talking about a medical source.
That's what I was going to say, but never use the word residual functional capacity in lieu of medical source statement, because the only person who gets to decide an RFC is the Commissioner of Social Security. And I've seen some sleazy attempts to get rid of our opinion by calling them RFCs when it's clearly not. It's our client's physician giving a medical source opinion on it. So tip to anybody out there, just change the name of your forms to medical source statement.
One thing that I always like to make sure that people understand about residual functional capacity, and when I say people, I mean judges too, because I feel like, and we talk about this all the time, like we're always having to educate judges on how to do their jobs, but RFC is not the average amount that you're able to do, it's not the least that you're able to do, it's the most that you can do, and that really comes into play a lot in hearings when we will, when a judge will throw out hypothetical limitations for a worker, and you and I know that whatever they're asking is the most that somebody can do, but many of the jobs that the vocational expert cites as available with that RFC at times will require a greater capacity than is there. For example, most light RFCs are coined as, requiring standing and walking for 6 out of 8 hours in a day. And even though a job may be light or medium, it's still, according to a vocational expert, consistent with that. If you really know how somebody is limited, you know that they, if that's the most that they can do, some of those jobs require them to stand and walk for 8 hours in a day. So that's something that gets lost a lot.
It's the nuance that vocational witnesses and judges are not used to. I mean, there's a running theme to every conversation we have. It's what other representatives, what is this rote system doing to our advocacy? Because nobody asks questions like that.
Right.
The vast majority of attorneys would never even have that thought cross their mind. They just don't think like that.
No.
They say, we reduce it to stand walk for blah, 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 blah. And then everyone just backs off.
Do you have any tricks that you've been doing recently in hearings? Is there anything new that you've been playing with?
Well, I don't know if I want to discuss it on... You want to give our tricks away? I mean, they're not tricks. They're
not tricks.
They're clever
it's food for thought.
Yeah, no, I mean, they're not tricks. It's what are we looking for? I think I've been very interested in what you just said about it, the most you can do, because we're seeing a lot of these, RFCs that are somewhat in the middle of two levels, which I think is very problematic, and I think it goes unaddressed in most hearings.
Yeah. A big one, and again, I don't think I'm giving the house away here. I want people to know that you and I know what we're doing, so I'm not scared to tell people, even for the benefit of other attorneys or people who aren't our client. I want there to be good testimony given out there, which, by the way, that's brings to light the next thing I want to ask you about, but a lot. Have you noticed that when they say medium work, most of the RFCs that are in the state agencies are stand walk 6 out of 8, but You can get VEs to testify that all medium work requires standing and walking for 8 out of 8.
There are absolutely jobs that are given all the time that are in excess of the assumptions that the agency's making. Housekeeping cleaner. My favorite question to ask, and this is not a trick, this is a common question. What task can be performed sitting down?
Yeah.
None. And they say no climbing or ladders, ropes, or scaffold. You hear all that kind of usual stuff. Well, there is some climbing involved with cleaning high places. It's just things that people aren't asking and they're not contemplating. It's terrible.
I don't think you and I have really gone into this, or maybe we have, at least not on Bonus Bytes. And I want to talk about it because it bothers me. There's so much emphasis on correcting the DOT. And I hate it. There's all these news articles, and who's behind it? Disability lawyers, but dumb disability lawyers. Disability lawyers who don't understand that the way that most cases are won is not by showing definitively that there's no jobs that our client can do. It's by pointing out the fact that Social Security can't meet their burden at the 5th step of the sequential evaluation to prove that there are jobs that a person can do. And as much as our job should be to prove on the merits that somebody's disabled at step 3 or step 5 or wherever it is along the way, it really bothers me that people don't spend enough time just focused on pushing that burden back on Social Security and saying, you can't cite any jobs that my client can definitely do. Now, when they update the DOT, when they correct like these emergency messages that are out there to say, hey, we can't take testimony about, addresser jobs anymore, whatever those jobs are, all it's doing is help Social Security write better denials.
That's what it's for. I think I'm not sure if we talked about this on camera, but I know we had this conversation. Yeah. It's that there's a lot of articles, Washington Post, celebrating this, and it's a complete misunderstanding of what's happened. Yes, Social Security sent a message to judges saying if it's these certain jobs that a lot of VEs like to rely on, document preparer, addresser, what have you, they'll now ask the VE, is the job still performed the same way? And the VEs, no, it's different, but it's the same. I mean, it's essentially what they're saying. I know. And so, you have to press them on that because there's no way they can know that answer unless they've done some type of labor market survey. And these jobs just don't exist anymore. Our economy has changed tremendously, and it's going to change more and more every day. And these unskilled, lighter-ish jobs just don't exist anymore.
Right.
And representatives need to wrap their mind around the fact that it is the agency's burden. That's step 5. And when you put that in the back of your head, I think it helps you form questions better. You're not trying to prove anything. It's kind of like reasonable doubt. If someone's charged with a crime, it's the state's burden to show that someone, is guilty beyond a reasonable doubt. But, in the court of public opinion, a lot of people who face charges, are proving their innocence.
Exactly.
That's not, you've got to change the mindset.
I did a TikTok video maybe a month ago where kind of the thesis statement of the video was, why do we show accused murderers more grace than we show people who are disabled? And where I continued from there is to say, the burden that's placed upon us as a society, we've decided that it is worse to convict an innocent man than it is to acquit a guilty man. But at the same time as that, we shame people who are applying for disability.
Mm-hmm.
And, Social Security judges always seem to take this standpoint of, prove to me that this person can't work without really understanding the flow of things. And we don't give people who have worked hard and paid into Social Security for a long time the same amount of grace and respect that we even give murderers.
I think that, one of our country's biggest problem is this mindset, this pull yourself up by your bootstrap mindset. We prioritize work often more than, mental and physical health. And it's changed a lot in the 15 years we've been doing it. We're seeing kind of a different shift in, how people are openly talking about their issues and seeking more medical treatment, but there's still, so much focus on if you're not working, you're just, you're taking something from the government. And it's a shame because I think what we're doing is we're helping protect democracy. And why I say that is because, this is a country with a government that is supposed to provide welfare. I just heard someone say, I always thought welfare was kind of like a bad word. Like sometimes when I explain SSI to people, like I hate to call it welfare, but it helps people understand the difference between that and SSD based on work history. But someone was telling me that, in the preamble of the Constitution, it uses the word welfare. Mm-hmm. And that's great. That's what our country exists for, is to provide security for people who can't provide security for themselves because of a medical condition or whatever it is. So welfare is a great word, and I think we're protecting that by doing what we're doing. So we have to challenge the government. Yeah. If you want to say it that way, I think it's totally fine to look at it as we're protecting democracy.
I agree with you. Well, as always, it's been an enlightening and enjoyable episode with you, Andrew. And I look forward to sitting back down with you in a couple of weeks to talk about the world that exists 2 weeks from now.
We'll see. A lot can happen.
All right. Have a good week, everybody.
Thanks for listening to Bonus Bytes, a mini episode of the Triple D podcast. Rate, review, and subscribe, and tune in next week for more disability news and headlines.